Citizens now convenes this public and confirmation hearing. Public hearing notices were provided to the media. First notice on Wednesday, September 2nd, 2015. Second notice on Tuesday, September 8, 2015. For the record, today is Friday, September 11th, and the time now is 9:04 a.m. The committee will hear and accept testimonies, both oral and written, on the following. This morning at 9 a.m. on schedule is the executive appointment of Ms. Sharon Davis as a member of the Guam Memorial Hospital Board of Trustees. Bill 168, an act to add a new subsection Q to subsection 3218, amending subsections F and G of subsections 3218.1. This is all relative to increasing the penalties for non-compliance and adding reporting mechanisms to better ensure enforcement. We also had Bill 72 on the agenda this morning, which is an act relative to amending sections 9C of Public Law 3254, relative to requiring that the National Clinical Mental Health Counselor exam is the sole requisite exam for licensure for licensed mental health counselors. This has been pulled from session agenda this morning and will be rescheduled at a later date. At 10:30 a.m. this morning, we have a status hearing with the Guam Economic Development Authority to provide an update on the hotel occupancy tax bond projects, the Guam Museum construction and flood mitigation projects in Tumon. And at 2 p.m. this afternoon, we'll have a hearing on Bill 143, which is relative to expanding the Natasha Protection Act of 2005. I'd like to acknowledge the presence of former Senator Robert Klitsky. Thank you, sir, for being here. Senator Nevis Underwood, thank you very much for joining me this morning. We'll start off this hearing with the executive appointment of Ms. Sharon Davis. We have Mr. Wade Davis and Larry Davis, who is here providing, just here for support, and they are in favor of the nomination. I'd like to now call on Ms. Sharon Davis. If you could please come forward. Good morning. If you can, can we help her just put the mic down and press that button there? Great. Thank you, Sharon, and it's nice to see you again this morning. I want to congratulate you on your appointment to the Board of Trustees, the Guam Memorial Hospital. And so I'll have you, if you have any prepared statements, to go ahead and proceed with that now.
Half a day, Mr. Chairman. Thank you for this opportunity to provide testimony on my appointment to serve the Guam Memorial Hospital's Board of Trustees. I'm humbled by the confidence that Governor Eddie Calvo has afforded me to be considered for this position. As a single mom, I raised my son, Wade, here on Guam. I've had the gift of support from our island community to raise my son here. I'm grateful for this opportunity to serve and give back to that community that embraced my family and I. While I have a full-time career at GTA, I look forward to contributing my attention in this civic capacity as a board trustee. I will focus on the primary mission of quality patient health care for the island residents at GMH. From my work experience, I will contribute a customer-centric perspective to support the management and staff in executing the GMH mission. I will bring the voice of the customer to the decision makers of GMH to develop products, services, and leading customer experiences. I thank you, Chairman Rodriguez, for your time this morning and respectfully request your consideration to serve as board trustee. Thank you very much.
Thank you very much, Ms. Davis. Senator Underwood, do you have any questions or comments?
I'll hold my questions
Okay.
until after.
Okay, great. Thank you very much. Ms. Davis, thank you again and congratulations. I know we had an opportunity to speak a little bit before today, and I've discussed with you at least my vision and and how I think the hospital will be 3 years from today, 5 years from today. But it is also, as we look towards that, as I mentioned, we do have a Gmh Task Force that I put together. We're looking at some viable solutions that we haven't tried, that we haven't gone down. And so we're looking at that. We'll be able to present that to the public. But even with that plan, that master plan for the hospital, there's needs for a short-term solution. And perhaps, you can share with the committee some of those short-term visions that you would like to see and that you would like to contribute to the board if you're confirmed.
I have not read or seen that plan as we've discussed. I think it's exciting that you've got a task force behind it and I'm sure they're looking for what the top 10 things are and going to go after the easy things that you can change immediately. But I read the other day about the maternity ward, which I think is very exciting. A lot of folks visiting that section. To be very honest, I don't have enough information to really give you what a vision would be, and I think it would be unfair of me to kind of throw that out there without really having all of that information. So I just look forward to participating and reviewing and asking questions and getting to the vision that the board has today. What I did when I was thinking about taking the appointment for the board is I jumped online, started looking at all the information that's out there. There's a nice plan that's presented, and I'm sure they're working towards it. I think it's exciting that the task force has been putting their energy behind something. That's a lot of work to do, and I hope to be able to be part of that. So as far as a long-term vision, I mean, I hope that they start making money, which seems to be the concern that everyone has.
Great. Okay, thank you. Yes, the report, the plan hasn't been published yet.
Right.
And so, when that time comes, we'll of course present that to the public as we move forward. But let me ask you, you're from GTA. You've worked there for many years, successful career there, and it's become a successful entity. Prior to it being run privately, it was the government of Guam who was running it. And as we move forward with this, the discussions at least for the Guam Memorial Hospital, we're looking at perhaps a public-private partnership in moving forward, and really trying to get the government out of operating the hospital. But of course, having, as I mentioned, the government still has to have to be a part of it, but perhaps not as the operators. And every time I talk, even with our task force, I always reference the GTA arrangement on how it was government and became, it was run by the private sector. You have one of the executives behind you now, so he's here. And so it's become successful, and so that's the type of models that, we're taking a look at. What is your position on that? Or, have you thought about it? Have you, since the last time we spoke, and is that something you think that now we have a new private hospital? And is that a vision that you think you could support and be behind?
Yes, absolutely. Again, I mean, I am a firm believer in looking at all the data and making decisions based on that, and talking to the employees there. And but for sure, I think that, as you said, and we discussed, that GTA is a perfect example of that. And it's important that you get the group of people that are working at the hospital behind the plan before you implement it. And I think that GTA did a good job of that and carried that plan through the first few years, which could have been a very difficult situation. We can't operate if we don't have employees. I think it's doable. I know that it's doable. We're at GTA. And so I think it's exciting to look at that in a different perspective.
Great.
Sure.
Okay. And that's why, I've said I support your nomination and your confirmation. I think having the knowledge of how that evolved from government to private, ensuring that we looked at a lot of factors, in the staffing. Now we have, and that's one thing that I'm going to ask you to do is, once you get on the board, is you really take time to meet the staff and talk to them, because that's the biggest asset of the hospital, is the employees that work there. And you hear it all the time. You hear that the care, the service was great there, but the facility, the physical and fiscal infrastructure is a big challenge for us. It has been for many years. but the employees have always been an asset. So, and that's, and you're right. You know, to be successful, you got to get them to be involved and to be able to support that. So, you know, I wanted to let you know that I do support your confirmation.
Thank you.
And that we'll move this through the process and get this through the next legislative session.
Thank you.
Okay, thank you. Senator Underwood?
Thank you, Mr. Chairman. Sharon, I do want to thank you for stepping up and being willing to serve as a board member. I did serve as a Guam Memorial Hospital Board of Trustees decades ago, and so I do know how complex this could be. But I do have 3 questions I want to ask you. What do you think is the role of the board in relation to management of the Guam Memorial Hospital Authority?
This would be my first board appointment, and thank you for recognizing the stepping up too. And I'll tell you, as I was asked to participate, I was very excited because I thought I could make a positive contribution, being where I'm from. So as I read through the bylaws that are published, I think that my role and the board's role is to guide and support and to push forward policies that make sense for GMH.
So let me give you a hypothetical situation here. You have a group of employees who will come to you concerning a situation that they have brought to the management's attention, but has persistently not been addressed. So how would you address that?
Address the group?
How would you address a complaint that a group of employees are bringing to your attention?
Well, I can give you an example of what I would do today with my own folks, and that is certainly listen in a very respectful environment. So, I mean, we wouldn't be having this conversation in the middle of the call center. And then ask them, well, listen and let them know that I'm hearing them, and ask them what they want to do about it. And if it is important to them so much that they want to put some energy behind it, I think that they'll write the things down and we'll get them organized and put them in front of someone who could make a difference about it. And I think what you're referring to is that would I bring it to the board and have them review it? I'm not sure how that complaints would be addressed at the Guam Memorial Hospital if it came from a group of folks. Is there?
So this actually goes to the role of the board that sometimes becomes a conflict with the operational operations of the organization, right?
Okay. I think I understand what you're saying. Okay. Well, what I would say is there's 3 sides to every story. You know, his side, her side, and the truth. And so I think it'd be important to get all of those sides and then put them in front of somebody if it was a valid complaint, I guess. I'm not sure is that we're talking about like somebody stole somebody's lunch out of the refrigerator, or they feel like they need to get paid more money. I'm sure there's rules for those things. Some things are simple to solve, and I think for the most part, Senator, folks want to be heard. And if they don't feel like they're being heard, then they're going to tell somebody about it. And if you don't address it, then it gets worse. They're not comfortable at their job, and that's hurts everybody, the company, the customer. So I think it's important that folks get heard.
So you would entertain the employees?
I would certainly listen to what they had to say, yes.
Would you involve the management at that point?
I think the questions that I would ask is if they did do it chain of command. Did you talk to your supervisor about this? Did you talk to your manager about this? And what did they do about it? Sure, those kind of things. I really believe that most people want to be heard. A lot of times those kind of, maybe somebody got their feelings hurt.
Well, Guam Memorial Hospital is, it's a very sensitive, it's highly stressful, and I wouldn't compare it to education, but having been at DOE, I clearly know that any given day, things could go wrong. And any given day, people will be happy, and then there will be those who will be not so happy. And so there's always something that might be brought to the board's attention. But what makes it complex and difficult for management is when the board would entertain the group without their knowledge, right?
Agreed.
And then you become a manager, because
Right.
once employees know that they can go to the board directly, then what's the point of going to, because the board ultimately, for some employees, is really the one who has to say so and can make the managers do what they want. So you know what I'm talking about?
I do, because
So the role of board members has to be clearly defined, right, in relation to the operations and in relation to the management, because then it can become very, very difficult for your managers. So I just wanted to ask you not to be difficult, but because this is really critical. Your
Right.
relationship to the management will determine the extent to which the board can really support, right? And it's in those complex interpersonal relationships or those conflicts that you will define your relationship. So I would just want you to think about that, right? What do you think would be the three policy priorities? You've been here, you know what's going on, the challenges of the hospital. What do you think are the three or two policies that you think are critical to the success of GMH?
coming from where I sit in my career, I would definitely say service. Service is important across any company. And interestingly enough, in all of the information that I read about GMH, there's not one measurement to service for those for that side of the house. Most of it is operational data about health and safety and that, which is also very important. So I would say service would be one of mine. And I think second would just be to keep, well, I'd like to update the website and give the public more information about what's really going on at GMH. So those two things, top of the mind for me.
Okay. Thank you, Mr. Chairman. Thank you.
Thanks for the tip, too, on the, it sounds like that was something that you were faced with when you were a board member, that folks were constantly coming to you, and then you really
And
had to
faced with
consider.
as a manager of the largest agency.
Right, right.
Great. Thank you very much, Sharon. Thank you,
Thank you.
Senator. You can switch off your We have Senator Espaldan. Thank you, Senator, for joining us this morning. We're about to wrap up this hearing on her. Do you have any questions for Ms. Davis? None? Okay, Sharon, I want to congratulate you again, and we'll move this confirmation process forward. Okay? And we'll keep the record open for the next few days, and the public is invited to present any written testimony if they'd like on the appointment of Ms. Sharon Davis to serve as a Board of Trustee member of the Guam Memorial Hospital Authority. We'll now move on to Bill 168-33. Thank you. We have Mr. Carl Espaldan to provide testimony. Director Gillen from Public Health, just written, or you're just here, okay. And former Senator Bob Klitsky. Please, yes. Thank you. This bill, Bill 168, is an act to add a new subsection Q to subsections 3218 and amend subsections F and G of 3218.1 and add a new subsection H to 3218.1, all of Article 2, Chapter 3, Title 10, Guam Code annotated relative to increasing the penalties for noncompliance and adding reporting mechanisms to better ensure enforcement. This was introduced by Senator Frank Aguon Jr. and myself. Senator Aguon is not able to join us this morning. He does provide us a sponsor statement that I will read into the record. I want to begin, Buenas and Hafare, I want to begin by thanking you for holding today's public hearing relative to Bill 168, relative to increasing the penalties for noncompliance and adding reporting mechanisms to better ensure enforcement. Unfortunately, I could not be here with you today because of prior off-island commitments. In my statement this morning, I would like to thank those of you in attendance today to testify on behalf of this measure, and I ask you to join me and Senator Rodriguez in making the measure better where necessary. Bill 168 provides a reporting mechanism for noncompliance that would require, within 15 days of discovery, the Department of Public Health and Social Services deliver a written notice which details the nature of such noncompliance to the Attorney General and Chairperson of the Guam Board of Medical Examiners. Furthermore, on a quarterly basis, the Office of the Attorney General shall deliver a report to the Director of the Department of Public Health and Social Services and Legislatura, which states in summary form what steps the Office of the Attorney General has taken in response to the events of noncompliance reported to the Attorney General in the previous quarter and the status of such noncompliance. It is remarkably clear that past abortion reports that were submitted to the Office of Vital Statistics by these current abortion providers have been incomplete, and to date, these providers have yet to comply with abortion reporting laws. Additionally, the measure would allow us to address the loopholes within current statute by providing enforcement provisions for the Department of Public Health and Social Services so we can ensure full compliance with these reports. As such, I hope that the Chairman, his Committee on Health, Economic Development, Homeland Security, and Senior Citizens, and those in attendance today will join me in making this measure better where necessary, allowing it to move to the floor during the next available session. Ondonklu Nasitus Maasi, very respectfully, Senator Frank B. Aguon Jr. We also have Senator Klitsky. We'll call you on the next panel, and Mr. Tim Rohr. Mr. Espaldan.
Thank you, Mr. Chair. Good morning, Chairman Rodriguez, Senator Underwood, Senator Espaldan. My name is Deputy Attorney General Carl Espaldan, and I'm appearing on behalf of the Office of the Attorney General on Bill 168-33. The Attorney General herself has previously communicated some of her thoughts and comments on the legislation with the bill's sponsor, Senator Aguon, and she asked me to be here today to present it to the committee and to be available for any questions you may have. Bill 168, in an effort to increase compliance with Title 10 abortion reporting requirements in Section 3218 and the informed consent requirements in Section 3218.1, adds the subsections that would require the Department of Public Health to report noncompliance to the AG and the Chair of the Guam Board of Medical Examiners, and then in turn require the AG to report back to DPHSS the steps that have been taken to address the noncompliance and the status of the noncompliance. We have the following comments. Section 3218, the abortion and post-abortion reporting requirements, has 4 penalty sections for noncompliance, 3 of which can be characterized as involving government action. The other one has to do with private action. As far as the government actions are concerned, there are 2 subsections that makes the release of confidential information in these reports a misdemeanor. Then there is a civil penalty for failure to comply with the reporting requirements, which is to subject the physician to a fine of not less than $10,000 and not more than $100,000 per occurrence. And we believe that the bill, on its face, we believe that the language in the bill has to do with these non-compliance reporting requirements having to do with the civil enforcement actions. The language of Section 2 of the bill itself appears to presuppose that the Attorney General's office is involved in the administrative enforcement of the reporting requirements. The Attorney General's position is that the Office of the Attorney General does not and should not handle the administrative enforcement actions, which includes the finding of noncompliance, the imposition of fines, and the administrative due process procedures, for example, the appeals, that should be a part of this process. These are more properly executive agency functions. The Attorney General's role in the overall process may be to enforce an imposed fine or penalty in court and to get a judgment paid. Or it may also represent the agency if a plaintiff appeals an administrative fine decision to the court. There would be a conflict in our roles if the office were involved in the administrative enforcement portion of any regulatory process, and then having to represent them in court later on. Section 4 of the Act requires a similar mutual reporting process involving public health and the Office of the Attorney General for Section 3218.1, the Women's Reproductive Health Information Act, which is essentially the informed consent law. In this section, we think it's more problematic in the implementation here because it is unclear, really. It is less clear that the non-compliance that DPHSS would or could report to the OAG. The only reporting requirement that we see in this section of the law is for the physician to report to GMH the number of checklist certifications that were completed on a monthly basis. There is no reporting requirement to the Department of Public Health and Social Services. And in fact, if the Public Health and Social Services were to get this information by any means, which we don't know if it's required to, we believe that the information contained in these checklists, which are required to be part of the patient's medical files, would be protected by HIPAA. So our reason for being here today, Mr. Chair, is just to point out to you in terms of how this would actually work or what this would do. We think that in one section, the reporting section, it may be thinking that the Attorney General's office, when in its call for us to report back on the status of noncompliance, it may presuppose that we're actually involved in the enforcement of the penalty, of the civil penalty. Now, the criminal side, yes, we would be involved in if there's a release of private confidential information that are contained in these reports. That will eventually get to us. We don't think that was the intent of the new section that's being proposed. And as for the second section, I think the director can speak more comprehensively about that, is the type of information that they would report to us regarding noncompliance. Thank you for the opportunity to testify, and I'll be available for any questions.
Great. Thank you very much, sir. Senator Underwood, do you have any questions for Senator Espaldan?
Actually, I'd like to read that testimony one more time. I mean, he came across. I guess the very basic question is, it seems to me that you're pointing out to this committee that the AG's office may find itself in a conflict, could potentially find itself in a conflict. Is that true? So I guess the implied recommendation is to really take a look at that section of whether the AG's office should be included as part of the administrative process?
Right, because it's unclear to us in terms of when HSS reports to us non-compliance, what our role would be at that point. Because HSS, if they find they have to make the determination of non-compliance, and if after that they can determine whether or not they're going to be imposing a fine. That's not the AG's decision to do that. And then whenever you impose a fine like this, and the fines here are pretty hefty, from a minimum of $10,000 to a maximum of $100,000, you can bet, and actually there's going to be a requirement for due process appeals hearings. And that's also an agency function, see. So it's an issue not only of a conflict, but also the separation of the roles, of the proper roles between the agency and the AG in this case. And then the conflict may come in later on, and there's always a potential conflict that if we're involved in the administrative process and it eventually gets to the court, we're basically essentially defending our own actions and not the actions, and we're supposed to be representing the actions of the agency and not ourselves. So that would put us in a conflict position.
Okay. I appreciate that. Thank you, Mr. Chair.
Thank you, Senator. Mr. Espaldan, we'll take that into consideration. If you can provide us a written copy of the testimony, and as we move forward in the markup, we'll ensure that we invite you as we move this forward so we can report this out. Okay?
We'll do it. We'll provide a written statement, and thank you for
Great. Thank you.
involving us.
Okay. Director Gillen?
Yes, good morning, Senators. I wasn't really going to say anything because we'd submitted just a short note saying we support the intent that, to get physicians who are doing these things to comply with the law. But as it's pointed out, there are some conflicts here with whether when we report to the Attorney General's office non-compliance, then they report back to us what they did, and because of the fines that are going to be imposed here, and these now going to be criminal, you can bet there are going to be requests for administrative adjudication. There's going to be requests for, we're going to spend a lot of time in court. I understand why people want to have this happen, okay? Because there have been some physicians who have been fairly careless about what they report, and we've been admonished by the AG's office that every report that's required under 3218, okay, it must be filled, and okay, so we realize that we're going to make sure that's done, but then there's a requirement to report to them and also report to that finding to the Board of Medical Examiners without understanding what the medical examiners are going to do with the report. And then we get into 3218.1, which is the woman's right to know and informed consent, which, as Carl brought out, may imply some issues of how we get access to the questionnaire that is supposed to be signed off by the woman. I mean, we all agree that this intention was good. Let's another 24 hours to think about what the woman is planning, and with all of the information that they can get regarding what's available for them and what the options are. We all agree that makes good sense. But now to really subject non-reporting, and I'm not sure how that works, because the questionnaire is really the only record, and that record is a medical record, okay? And I don't know how we access that unless the woman brings some action, okay? I'm really not. It's not clear to us how that gets operationalized, and that's all I think about is when people provide these kinds of pieces of legislation. How am I supposed to make it work? And how are we gonna make it work efficiently and effectively? But this one raises those questions again, because that is a medical record. Outside of that, those other issues with the AG's office potentially having to represent us, but at the same time, doing some administrative work, which puts them in a conflict. Really, we need to clean this up a little bit, or it would be a lot.
Okay, great. Thank you very much, Mr. Gillen. Any questions for Mr. Gillen? Senators? None? Thank you. We'll excuse you now. So we'll call the next two individuals, Senator Klitsky and Mr. Tim Rohr.
Good morning, Mr. Chairman, Senator Underwood, Senator Espaldan. Mr. Chairman, might I have your leave to allow my friend Tim Rohr to proceed first? A couple of reasons. I think his testimony is very poignant and tends to lay a foundation for the things I'm going to say. Mm-hmm. Second, I always like to get the last word if I can.
Okay, great. No problem. Mr. Rohr?
Thank you. I'm used to giving the last word. I have here my agenda. I'm going to do a short presentation over there. But I do have, and I believe it's passed out to you. And that is
due to a lack of enforcement is something we don't have. Additionally, whether it is the present bill or some modification thereof, I believe you will see that an enforcement mechanism for the responsible reporting of abortions is needed, and there needs to be some agency that has the authority to see to compliance. So if I could draw your attention to a couple of charts.
If you can use the mic so we can, this is recorded.
All right. We'll start with this one. Just let me know if we're good here. So, as you can see, what we've done is requested let's back up a little bit. In 2008, I first requested all abortion reports that Guam Medical Records had on file. We received reports beginning 2000 to 2007 at the time. Okay, the abortion reporting law has been in place since 1994. So, thank you. So there was 6 years that were completely missing. Okay, and of the reports we did see, and I've attached them. We did get one for 2000. 2001 was completely missing. 2002 was a completely blank report showing 0. And then we had 20, 66, 47, 20, 61. And then in 2008, we had a 700% increase to 327. Now, why is that? Well, Public Law 29-115. What was that law? That was the imposition of the fine. It's important to notice because in this very long battle of trying to get some sort of regulation for abortion, in fact, the reason why we got started in 2008 is because in a study by Americans United for Life, a large national pro-life organization, Guam came out dead last in its protections for the unborn. In fact, out of 50 points, we had 4. The next to last, Oregon, at 20 points. So Guam is the most dangerous place in the United States for the unborn. Yet we celebrate ourselves as this wonderful pro-life family culture. So we decided to do something about it. So you can see that physicians need motivation. And that's why you see this. They said, well, I don't want to get fined, so I'm going to actually turn in the data that was required by law. It's important because in this battle, we have been constantly criticized. Who are we, to tell doctors what to do? They know their job. Politics shouldn't get involved in medicine. We're just making it hard on doctors to do their job. Sorry, but they have to follow laws like every other businessman. And I have to turn in my reports as a businessman, and so do they. So that's why we have a 700% increase. We might just call that a little bit more honesty. But then, and as you can see, the abortions kind of go, well, we're up over 200. We average an abortion every 1.7 days, right now. 73% of which are tumoral children, by the way. So, since that law with the fine came in place, of course, I guess what they didn't realize was, at first, they did start reporting a little bit better, but there was no enforcement mechanism. And I think they figured that out pretty quickly. Because, I'm not going to go through all this, but you have all the reports in front of you, and you can go through them. I noted a total of 3,136 missing required pieces of information on the abortion report starting in 2008 when that public law first went into place. I calculated that out, and at a maximum fine of $100,000, we could all get our tax refunds back every year, no problem, for a long time, right? That's a joke. Okay. I hope getting the tax refund back is not a joke, but the fact is that there is a consistent and persistent ignoring of the law. And Mr. Gillen can share with you if he wants to, but anyway, he knows that we've been in contact with this because last year, with the bill that you introduced, the abortion reporting abortion reports were redirected to his office instead of the medical records, and they became the agency as the beginning in 2014 of actually collecting those abortion reports and so on. And so we had already gone through this with medical records for a year. We've already contacted them every year and says, where's the missing data? Every year they told us, well, we can't do anything about it. And so same thing with, and we understand that, you know, but we thought, well, we're just going to keep trying because here you have an issue that nobody wants to see. Everybody agrees abortion is a tragedy, okay? But we can't make responsible policy without reliable data. So this is not a pro-life, pro-abortion thing at this point. This is about whether or not you legislators care as to whether or not the laws of Guam are actually followed, because there was some good laws. There's some good laws in place. There's the abortion reporting law, and by the way, the information that's required to be reported is simply statistical data. Has nothing to do with the privacy of the patient. The patient's name cannot even be on the report that's submitted to the office. It's just the numbers. And by the way, the checklist certifications with the informed consent law, they don't have to turn those in. They only have to turn in the number that they actually collected. A number like 15. That's all they have to do, right? That law it was implemented in June of 2014. And this year we did a FOIA request on how many of those reports were turned in. Zero reports were turned in, okay, by the abortionists. There was some media attention to it. I think a total of 106 abortions were unaccounted for, no checklist certificate, 106 times, okay, and the doctors were in the paper quoted as saying, we're following the law. The law says you have to turn in the number. You turned in nothing. We're following the law. Why? Because they're not afraid. Okay. So the data is undeniable. The law is being ignored. It's being ignored. Why? Because there's no enforcement mechanism. That has to be addressed. Otherwise, lawmaking is a joke, and this law is a joke, and we're losing a lot of children here. We need to address the societal factors that are underlying this basic tragedy of disposing of a child on almost once a day. 73% of which, of course, are local. Something needs to be done. We need to get the data, okay? We can only say, we need to ban this and ban that, but everybody knows that there's underlying societal factors that have to be addressed. Those cannot be addressed without the proper data. We can't get the data because there's no enforcement mechanism. So I advocate, I realize there's some issues with the bill, but I advocate and support the intention of the bill and ask you to move forward on that. Thank you. Any questions?
Thank you very much, Tim. Senator Underwood?
Thank you, Mr. Rohr. I just have a question. You know, in any given questionnaire, I imagine that this missing data is from a set of questions that is asked of the mother, right?
Correct.
And so could the missing data be as the result of the individual just not providing it?
The doctor, if you want to change the law, change the law. But the law requires that that information be provided, period. So the doctor then can refuse to do the abortion if the woman won't provide the information. But he's required by law to provide that data.
Every data element has to be provided before the abortion occurs.
No. If you look at the law 3218, some of it has to do with post-abortion complications, blood factors, all kinds of issues. I recommend to do a thorough examination of the law. If there's anything there that you don't want, you guys are in charge. You can make a law that gets rid of it. But the majority of the information, actually, if you look, is actually supplied by the abortionist. They're the ones who determine the gestational age, all of those kinds of things. So it's, I would say 50-50 if you look at it. But the law requires it. If the woman refuses to give it, the doctor can refuse to do the abortion.
Thank you, Senator. Senator Espaldan?
No, that's fine. Thank you.
Okay, great. Thank you very much, Mr. Orr. Senator?
Thank you very much, Mr. Chairman. The remarks that we've heard this morning provide a nice predicate for my testimony. Tim has shown us that there are failures to do the reports that are required by law. I suspect that if we asked any senator, he'd say, we don't like it when we pass laws and people don't pay attention to our laws. If the legislature passes a law and no one obeys it, is there sound? The old philosophical question. Jim Gillen has told us that he'd like to, but there really isn't much that he can do given the current tools that he has available to him. So with that predicate this morning, I'm going to start out by saying that the Scofflaw Prevention Act of 2015 would make a nice short title for the bill that's going to result from this public hearing. By increasing penalties and strengthening enforcement mechanisms for failure to make statutorily required reports, the law would make it more costly for abortionists to thumb their noses at the law. This is as it should be. A public perception that some can ignore the law with impunity tends to breed disrespect for the law by all. The key officials in the enforcement process are the Director of Public Health and Social Services and the Registrar of Vital Statistics. The apparent efficacious point of enforcement is the Registrar. In the spirit of Senator Frank Aguon's remarks, which you read this morning, Senator Rodriguez, asking us to help him make a good law better, I do have a few rather humbly submitted suggestions here. Section 22, as you were 3218, labeled partial birth abortion and abortion report, I suggest inserting the word complete at the beginning of the section, because part of the problem has been that people abortionists turn in reports that aren't complete. And I suppose there's something to talk about. Well, I turned in the report, I just forgot half the items or whatever. So inserting the word complete, I think, addresses that. By requiring that the reports be submitted under penalty of perjury, a certain fudge factor is eliminated. People tend to pay more attention to papers that they submit over the seal of a notary public or under penalty of perjury. The papers are to be filed as opposed to, transmitted. I don't know exactly how you would transmit the report, but they're to be filed. And file has a particular meaning that the lawyers pretty well understand what the word filed means. And they're to be filed with the Registrar of Vital Statistics. Throughout the statute, the term Office of Vital Statistics is used, and I would suggest that a one-liner be inserted in the statute that says wherever Office of Vital Statistics is mentioned, it means the registrar, because you can't hold an office accountable. As a matter of law, an office really doesn't exist. It's not a fictive person or whatever. A week would seem to be the appropriate time to submit these reports. And my second suggestion goes along the same lines. Filed with the registrar, 7 days under penalty of perjury, and the same with my third suggestion. Then I suggest that it might be efficacious to add a new section 1101 reading, the Director of Public Health and Social Services shall take cognizance of and require the enforcement of the mandates of sections 22, as you were 3218 and 3218.1. Believe it or not, I looked through Title 10 and I couldn't find very much language on what the Director of Public Health and Social Services is supposed to do. I don't think we really need to tell him, but it's helpful to have a statutory mandate when you go about enforcing the law. Technically, if you go about enforcing a statute that even is addressed to your department and you don't have a statutory mandate to enforce that statute, you're nothing but an officious intermeddler. So by inserting this section here, we give the director not a hammer, maybe just a little tack hammer or something that he can use here as a tool. I would suggest that new items 5 through 9 be added to section 3208, which deals with the duties of the Registrar of Vital Statistics. 5, ensure the completeness of all forms filed with her pursuant to 10 GCA, etc., right? I think under the current state of the law, it's arguable that the registrar, sort of like the clerk of court, the abortionist files a paper, the registrar takes it, and that's it. But this addition to the statute would require the registrar to examine the paper and make sure that it's in compliance with the statute. And if it isn't, the registrar then gives prompt notice to the abortionist that his papers are not complete, and that a 25-item paper from which only one item is missing is the non-filing of a report, basically. It's either complete or it's a non-filing. And that the abortionist would have 7 days to file a complete paper, or it would thenceforth be treated as a failure to file, and a couple of penalties arise. The Attorney General is noticed with respect to criminal sanctions, which I'll get to a little later on, and the Guam Board of Medical Examiners is notified as to this failure to file. I submit that 10 GCA section 3218K requires some clarification. That section reads, failure report under this section will subject physicians to a fine of no less than $10,000 or no more than $100,000. And my comment there is, if the fine is to be levied for a criminal offense, subsection K should be cited somewhere in 9 GCA. That's where we put our criminal laws. And it should be set forth in standard criminal law language, so that the nature of the offense is set out and reference is made to the penalty provision. And as I point out, language properly cited, limited to violations of 10 GCA 3218 and 3218.1 could work. If you look at K from another angle, it doesn't appear to impose a civil penalty, as the requisite mechanisms are lacking, as per the testimony of Attorney Espaldan. For instance, citation, notice to appear, adjudication, due process, etc. Consideration might be given to a statutory regime that empowers the director to issue citations for violations of 10 GCA 3218, 3218.1, with adjudication to be accomplished by the use of 5 GCA Chapter 9, Article 2. That's the second part of our administrative adjudication law that provides for notice, hearing, appeal, etc., etc. Law might have to be tweaked to accomplish this, but I think it could be done in such a manner as to pass what I'm going to refer to as the Espaldan test. Several of the provisions of the bill deal with reports and reporting requirements, none of which appear to be non-germane inter se. The rest of the bill, that is all of Section 3 except for subsection F, deal with medical malpractice, a distinctly different subject than dealt with by the other sections of the bill, giving rise to a finding that the two prongs of the bill are not germane inter se. I don't think I need to elaborate on some of the pitfalls of overly broad drafting of bills. Anyhow, Medical malpractice is a complicated and complex subject, perhaps best dealt with by a standalone bill. Sections 2 and 4 of the bill, again, which the Deputy Attorney General commented on, would add statutory language to the law which appear to be at best precatory and could be removed from the bill without diminishing its effect. In the sincere hope that my humble offerings would be of assistance, I urge the Committee on Health, etc., to perhaps after a markup or whatever, expeditiously report out Bill 33-168, incorporating such changes as the committee finds appropriate with a due pass. Let it be said, we just say no to scofflaws. Thank you, Mr. Chairman.
Senator, thank you very much for that comprehensive testimony. It's very clear that we do need a markup and to make revisions and to make this bill work. So we'll definitely do that. We'll reach out to you as well when we do have that markup. I want to ask my colleagues now, do they have any questions or comments on their Underwood?
You know, this question may probably not be necessary, but you know, you had certain suggestions that I felt would be covered by standard operating procedures or rules and regs in implementing the law. Like, for example, if the report is incomplete, then they would simply reject it, right? Would that be something that would have to be included in the law, or would that be something that could be specifically addressed in the do we call it standard operating procedures in implementing the law?
Well, there are a couple of different kinds of rules and regulations. There are rules and regulations called interpretive rules. And an interpretive rule is an agency's own interpretation of its organic statute. In a litigation situation, an interpretive rule has its power to persuade and nothing more, but it can't add to the law. It can only be an interpretation of something that is at least arguably present in the statute underlying the agency promulgating the interpretive reg. A legislative regulation is a little different. It goes farther because a legislative regulation can actually enact substantive law provided that the statute that would permit the promulgation of regulations contains standards. We don't have, first of all, there is no regulatory language in the law right now that would allow the director to promulgate rules concerning this. So there aren't any legislative rules to start with. Second, the way my suggestions are set up, the failure to file a complete report, as we've discussed it here today, gives rise to penalties. And when it comes to asserting penalties, that's not easy. It's not probably not something you should entrust to an agency through the rulemaking process, because it requires a very carefully drafted statute, and it is a surrender of the legislature, one of the legislature's prime prerogatives, that is to penalize, punish whatever misconduct, misfeasance, or maybe even nonfeasance. So I would think that if the director had taken it upon himself to say an incomplete is a non-report, it might be seen as, especially in the absence of any authority, statutory authority for him to get involved, it might cause more problems than would necessarily arise in the enforcement of this, especially in the face of what some might say is a very clearly worded provision. Senator.
Thank you very much.
Thank you, Senator. Senator Espaldan?
Mr. Chair, at this time, I was wondering if it'd be possible to call back the Director of Public Health now that he's heard this testimony. It kind of changes some of the perspectives from the original bill, and I was wondering if he might want to comment on that, or at least, perhaps, just give his initial reaction. I would appreciate that.
Okay, and then just also, please consider that I will call a markup meeting so that we can, have what we received here this morning and discuss it there too. But yes, we will allow the director at this point.
Thank you. Thank you for inviting me back.
Well, thank you, Mr. Director. And again, you've heard Mr. Klitsky's testimony and some of the changes that he's advocating for. They sound reasonable. However, again, from your perspective, in terms of what you need to do and what your agency needs to do you have any initial thoughts at this point? I realize this is still going to go through some kind of mutation after all this testimony has been provided, but just your initial thoughts.
Yeah, as I said earlier, my job is to operationalize a lot of things that you folks see fit to pass as laws. And I think Mr. Klitsky is right on point. We need to make sure that we do this right. For me to find, or the registrar to find, that a report is incomplete, and then there's no way to do anything about it, we need to go through that process, make sure we get that right. We need to look at how we're going to relate our actions to the Board of Medical Examiners, even though there's some language in the law that says they can take some action, but it's not clear what it would be unless they found it to be malpractice. But that's another can that we open that might be a problem for us. So this needs more work, and I think we all should be sitting down making sure this is right. And I think Mr. Rohr is correct. There's a lot of things happening. Nobody's standing up for the unborn, and getting more data will help. The only thing I get concerned about, again, is access to the data that may be able to identify an individual, even though there's no name being presented. When you have 24 data points, there are people who are very skillful at being able to identify, who the person is. I've seen that in being able to, it's been a concern with HIPAA for a long time when you see obituaries and you get somebody's name and age, and you can backtrack to find out just what it is that caused their death. So we have to make sure that we're very careful about access to the data, who gets to look at it. But I agree, this is more than just the matter of an abortionist doing what they do. It's trying to find out what the societal problems are, where the points are in the society that we need to get to see if we can help cure some of this, because it's more than just a reporting requirement. It's really is an ethical and moral issue that we have to deal with. So I would like to do more work on this, because if we do it, we better do it right. Yes, there will. What that is, I don't know. But I mean, we've already been, mandated to do certain things, and we haven't done them. So now that we pay attention to this, that takes attention away from something else. And it's just like a lot of things in environmental health. 26 mandates and only 2 are funded. So it's these kind of things. But we all know that the pie is only so big. You got to figure out how you're going to get things done as best you can. But yeah, there will be a cost, and I think going through this markup process will help us identify that.
Okay, thank you, Senator. We'll definitely consider that. Absolutely. All right. Thank you very much, gentlemen. Senator, thank you. Sure.
On the abortion reports that you have, on the copy of the abortion reports that you do have, if I could draw your attention, well, actually, to every one of them list the facilities for possible, well, that supposedly do abortions. You'll notice it's almost always the women's clinic or the polyclinic. Those are the two known abortion facilities. There's also a space there for Guam Memorial Hospital. Guam Memorial Hospital has consistently said that they don't do abortions there. There is an issue that I think will be addressed separately, that there are a lot of, well, I don't know a lot of, but there are fully formed children in the morgue that certain funeral homes pick up and dispose of their bodies on a regular basis. A couple years ago, the Catholic Church buried 30 at a time. Fully formed children, not just blood spots. So something's going on, and I just would like to draw your attention to this, and you can deal with it as you will. But in the 2007 report, if you would go to that. Sorry, I'm looking for it. You will see. Sorry, let me get my own copy here. 2007, did you find it? Okay. I'm getting that. Okay. Yeah, okay, thanks. I got it. 2007 report, you'll see that only 61 abortions are reported, and you'll see in the facility, you'll see that there's only one place that they were done, the women's clinic. However, if you turn the page, you will see attached to that separate pieces of paper that are not reports that have numbers from Griley's clinic, the polyclinic, also for 2007. And over the course of January, March, May, and July, there were 151 abortions. And August, September, October, November, December, another 73. 234 extra abortions that happened that are not on the report from Guam Medical Records. Only 61 of women's clinic was reported. So that's the official report. But there's these two other pieces of paper. I don't know how I ended up with them. Actually, they were given to us by Guam Medical Records, probably by mistake, but we have them, showing 230-something extra abortions that are not recorded as part of the official. Now, that's a lot. And that clinic was completely left out. Additionally, I'd like to draw your attention to the one piece from the polyclinic where it says total number for 5 months, it says 73. Find that? If you look below, it says total number of saline abortions completed and delivered at Gmh, 10. But Gmh consistently tells us they don't do abortions. Griley says they do. In fact, I have a lot of other evidence that says that they do, that I'm not going to do here. But the main thing is that Dr. Griley says he did 10 saline abortions. Saline is late term, full body abortions. He says he did 10 at GMH. GMH reported 0. I don't know how that's going to be looked into, but by giving the tools to the Office of Vital Statistics to be able to follow up on these things, perhaps we can get the real numbers and we can begin to seriously address the underlying social causes of what's going on. One of the most important things here, you'll see the most outstanding number, okay, is 1,582 missing pieces of data. Guess what that's next to? Highest education level. And I hear from the legislature so often about the importance of education in this matter. Yet that's the number one missing piece of data. We don't know what the education level is of many of these people. So those are just some numbers for you to chew on. Thanks for the second opportunity.
Thank you very much, Mr. Orr. Thank you to the panel. We do have additional individuals who wish to testify. I'm going to call them up. I'm going to ask Maria Espinosa, Patricia Perry, Mary Lou Martinez, Serena Mofnis, Michelle Rohr, and Jessica Rohr, that you wish to provide oral testimony. If not, we do have you here in favor of the legislation. I just want to request that if you do present a testimony, we do have another scheduled item on the agenda at 10:30, so if we can just limit the amount of time of testimony, I appreciate it. Thank you. Please, you may start.
Oh, okay. I will
make sure the button is
It's on. Okay, I will support this bill, and I will support any bill that'll impede abortion, but support the protection of all human life from conception to natural death. Thank you.
Thank you very much. If you can just state your name for the record.
My name is Patricia Perry, and I'm with the Catholic Pro-Life Committee. I'm representing Gannett Cathedral Basilica.
Thank you.
Good morning. My name is Mary Lou Martinez, and I'm here just to go on the record to say that I support the intent of the bill. Thank you.
My name is Michelle Rohr, and I am a board member of the Women's Resource Center, and I am here to go on record and say that I support the intent of Bill 16833.
Thank you very much, Ms. Rohr. Mrs. Espinosa?
Maria G.P. Espinosa. I do have written testimony, but not in front of me. I emailed it to your office, and there's a little technicality, and I just jotted down some basic notes so I can give you the overall testimony that I have. I do support the intent of this bill, and however, as I read thoroughly 3218, it specifically says, first of all, Article 2 refers to vital statistics. And so as I was reading all the details, it just seemed like some sections were inappropriately placed. In general, not knowing really where it belongs, but some things are not related specifically to vital statistics and could be restated in as another section of Title 10. Okay? And I had to make that clear because I was wondering what all these numbers represent. And then specifically 3218 is partial birth abortion. Okay, first of all, we no longer it's illegal to have partial birth according to Title 10, Chapter 91A, if I remember correctly from my notes. And so under 3218, it refers to, talks about, in section M and N, specifically that reporting of partial birth abortions has to be reported by two different entities. And so I felt that because it is already illegal to have partial birth abortion, that we should insert a few words to preface those reporting, because it is data. We still need the data, but I felt that so that nobody is confused, that we should at least insert the words, although illegal, partial birth abortions should be reported. And it's in subsections M and N. I do remember that. Okay? And then, so that specifically addresses 3218. And then when I went over 3218.1, that's the Informed Consent Act. And I don't remember the subsection right off, but there's one area where it does refer to that the woman may not be liable if she withdraws. She says no, she doesn't, last minute she doesn't want to have the abortion, or if she continues to have the abortion, whatever she decides, that she won't, she should feel confident that if she should require any kind of medical follow-up as a result of either having the abortion or not having because of her physical, maybe she's undergoes some physical illness, that she should feel confident that she will not be deprived of any medical attention from the local funding or federal funding. Okay, so that means either MIP if doesn't have any insurance, or Medicaid if she qualifies under Medicaid. So even though this particular part of my testimony does not specifically relate to this bill, but I feel given that there are at least 7 states which have already gone through the defunding of abortions in their states and their jurisdictions, that we should address that issue. Because why should an elective procedure of a woman who chooses to have an abortion, why should our government fund her abortion? It's an elective procedure, it's a personal choice. She should pay for it herself. And so this particular item may not specifically be addressed in this bill, but hopefully that there will be a follow-up meeting to hopefully to introduce a separate bill to investigate, first of all, have any monies been used from MIP to fund any abortions, have any monies been used from Medicaid. Certainly our budget for Medicaid is very, very limited here on Guam, and we shouldn't have anything that's elective, at least for abortion, should not be funded. And those 2 areas, one from 3218 and 3218.1, I have those specific suggestions. And
Okay.
Thank you for your time.
Great. Thank you very much, Mrs. Espinoza. And we do have your written testimony.
Do you have it?
Yes, we have it. So
Oh.
we'll ensure that we include in the committee report and take all your suggestions into consideration. Okay?
Thank you.
Thank you very much. Thank you to the panel. Thank you. There are 2 others, Ms. Serena Mofnes, Ms. Jessica Rohr. These are the last 2 for this bill.
Good morning. My name is Jessica Rohr. I'm the president of the Women's Resource Center. I'm here to support the intention of the bill, and I agree with Mrs. Espinoza. We shouldn't be funding that kind of procedure. It doesn't cure anything. And I just want to also say, if I can, that the organization, the Women's Resource Center, our intention is to provide positive alternatives for women. We will not be government funded. So our intention is to reach out to those people who feel the need to have an abortion and educate them on abortion, which is why I support this bill, because it's hard to educate people on abortion if we don't know how many abortions are actually taking place on Guam. So I support this bill.
Thank you very much, Jessica. And perhaps at another time we can invite you, and we'll do a roundtable, and you can do a presentation on the Women's Resource Center so that the public as well can be informed of what services you can provide. So thank you. Serena?
Good morning, Senator Rodriguez, Senator Underwood, Senator Espaldan. My name is Serena Mofnes, 22 years old from Talafofo. I'm also a board member of the Women's Resource Center, and to have the data of the reporting of abortions is so crucial to what we do, so that we can understand how to, help more women, and to understand that there are how many women actually need help. As far as making these really life-changing decisions, and I also just wanted to address, just to kind of bring up the importance of asking yourselves, why is it that there's such a hard difficulty in getting the reports, something so simple as statistics, and from the doctors who we trust, and who we trust to help us women. I'm a woman. As a woman, I want to know that my doctor abides, is a law-abiding citizen, and it's just really important to know that. And I just wanted to say that I support the intent of this bill, and and we hope that this bill will help, just everybody to help everybody understand how this, like Tim Rohr said, and a few of the other gentlemen here said, how it affects our society. So that's all I have to say.
Thank you very much, ma'am. Thank you. So we'll keep the record open for a few days or until such time we report this out of committee. And so those who wish to provide written testimony can still do so by sending it directly to my office. Okay, so this now concludes the hearing on Bill 168-33. We'll take a short recess. It's 10:25, a 5-minute recess so that we can transition into the status hearing with Gita. So we're in recess.